Good evening. Welcome to PressPass. My name is Masai, and tonight I have a panel to help us discuss the bigger picture and what the new cybercrimes bill, actually law right now, because it was signed on Wednesday by the president. What does that mean for journalists, for bloggers, other stakeholders, as well as you at home? And many people say that, the group admins have been worried after this was signed into law. We'll see if there's reason for you to worry. Let me introduce you to my panel tonight. I have Dennis Itumbi. He is in charge of, he's a State House Secretary of Digital Communications, and he will clarify to us whether he was fired, as that rumor was going on, the fake news, and probably that's what he will be addressing tonight partly. Next to him is Mutemi. She is an advocate on internet law and has a lot to share on this because she has actually been on other media houses such as KTN. Very good discussion that you had there. And yes, we are covering this because it's of concern to our institution, and that is our profession more, I should say. Henry Maina is at the far end there, crossing his hands. Body language says he doesn't want to speak much, but he has a lot to share. Henry Maina is the Regional Director, Article 19, and also is, of course, a bigger brother in the profession of journalism, has been here years back. And James Wamathai, next to him, is the Director of, that is Henry Maina, Mr. Director, and next to him in the African shirt is James Wamathai, the Director of Partnerships at BAKE, that is a Bloggers Association of Kenya. That is there, Mr. Africa, James Wamathai, right there. Good shirt you have on. Thank you for joining us this evening. And yes, to put it straight to the discussion that we have at hand, after the signing of the Computer Misuse and Cybercrimes bill into law by the president, and that is on Wednesday, there was a lot of concern by stakeholders and even Kenyans as to what this means for them. Ken Mijungu filed this report to put it into context.
Finally, something that will have someone thinking before a social media post is made, a video is recorded, or some random offensive words are thrown around. The Computer and Cybercrimes Act is here. President Kenyatta put pen to paper, turning into law one of the most contentious bills in the recent times.
The idea is not, the idea behind laws like these ones, and is not to go after everyone, is to go after specific people who step on specific powerful tools, and you'll see even the application of it is going to be very, very selective. This is how these things work.
James Wamathai is one of the representatives of groups targeted by this law. Bloggers are among the biggest losers since they thrive on content, controversial or otherwise. They literally live on the net. This is why they are apprehensive.
The purpose of this is basically make sure that people don't create content and don't express themselves freely.
Currently, one of the well-known bloggers in the country is battling cases in court after wedding in areas that not many dare contemplate. But it's not only personal matters that may land one in trouble with this law. Fake news, a relatively new phenomena that increasingly challenges the mainstream content, is put to check.
Issue number one, that section actually is going to reintroduce, actually it has reintroduced criminal libel. Remember last year the court actually declared the laws on criminal libel unconstitutional. So if you look at an act of parliament that is talking about imposing fines, that means that definitely we are going back to a law that has been declared unconstitutional.
Mainstream media now has to be even more vigilant with their content. This law criminalizes what would ordinarily be a fair comment or statement made in the line of duty. The last attempt to criminalize aspects of journalism practice fell by the wayside.
These people are going to go against the ethics and code of conduct for practice of journalism in this country. And we know that the only body that is allowed to do that is the Media Council of Kenya through the Complaints Commission.
Clause 12 for the law makes publishing of a false, fictitious information criminal and will attract a 5 million shilling fine or a 2-year jail term. Many hoped that the president will not assent to this law. To their disappointment, Many stakeholders, however, say they will go to court to challenge its constitutionality. In the meantime, the punishment spells doom to offenders. Using illegal devices and access codes will earn you a 20 million shilling fine or a 10-year jail term. Getting involved in child pornography will get you fined 20 million shillings or 25 years in jail, while cyber stalking or bullying will earn you a 20 million shilling fine or a 10-year jail term. The push for this law was stepped up after members of parliament complained of being cyberbullied by an individual. The subject is now involved in an active court case. But then there are some positives to the law. Social media users are protected against data harvesting. In the last few months, the issue of data harvesting has been on the headlines after it emerged that one of the firms involved in the last general election unlawfully mined and used private data. The law takes effect immediately. Ken Mijungu, NTV.
With that context in place, let's put it to the panel in terms of what you've been tracking, the coverage of this particular issue. I'll start with Henry. And in your view, do you feel it has captured a report like this and others that you've seen, whether on the press, has it captured the concerns or what this new law is aiming at?
Yes, I think to a large extent it has, even though it has missed a number of issues that the law seeks to deal with, and therefore, if it had covered issues of cyber attacks, which then can be manifested into different types. It could be cyber fraud, it could be cyber espionage, and many other provisions, cyber terrorism, which are within the clause, then that would have made it complete. But without making reference to those, it then seems like the law is only speaking to content restrictions, which are the last part of that. It also doesn't speak about the big challenge that has existed, that there wasn't proper coordination within government agencies in the event that there was a cyber attack, because there are aspects of cyber security that sat in the Ministry of Interior, and there are others that sat in the Ministry of ICT. And there are some officials who sat at the Communications Authority. That in itself used to cause a problem. If you remember the last global attack, the CS ICT gave a statement by saying we may have been affected, but didn't want to divulge as much. That in itself meant that we needed a proper coordination center. Okay. So the idea that the law comes up with a strong committee, which has the now ultimate responsibility for our cyber security, is a good thing. And perhaps the coverage that I've seen haven't said much about it, so that in the event, as a Kenyan, you control critical information infrastructure and you suffered an attack, then the first complaint you need to make is to that committee, why didn't they protect you? Right. Because then they would have resources to do. So
that's one main part that you feel hasn't been given the attention. To James Wamathai, you were in that piece and you are against this and in fact planning to challenge this in court. Would you just give the concerns of the bloggers?
The concerns of bloggers are on two things. First, on section 22 and 23 that are concerned with false news. We feel strongly that this is against freedom of expression and freedom of the media. And in any case, any limitations to those two rights are very well spelled out in the Constitution, in section 33 and 34 of the Constitution. So we did not need this law.
Yes.
We did not need this law, in my opinion. And then also, part of it, like the KUJ Secretary General said, part of it is criminalizing, libel and defamation. And you remember last year, criminal defamation was thrown out, or rather was declared unconstitutional. And so I feel this is bringing that particular facet through the back door.
Okay.
Something else is section 16 and 17 that deals with unauthorized interception and unauthorized interference. There can be an interpretation that can be used to fight whistleblowers. And if you remember, bloggers were very instrumental in bringing out the private corruption at Chase Bank and National Bank. And at the time, especially for National Bank had said that it was going to go to court. They were going to go to court. They were going to, petition the Inspector General Police so that these bloggers would be arrested because of all the things that they're saying, which they claimed at the time were untrue. But at the moment, all these people the people who were in charge at the time are in court. So in essence, it was true.
Yes.
Chase Bank, a lot of people went after bloggers because of all that, what happened, the fallout, that happened on Chase Bank. Even the CBK, the CBK governor was on record saying that, the Chase Bank was brought down because of online users and bloggers, which was untrue. I mean, later investigation showed that there was just massive corruption.
Yes.
And, to
so
be honest,
substance to what you
exactly, yes. So we feel that section 16 and 17 is going to affect that. It's going to affect in general whistleblowing. So I can't get information because the person who gives me and the person and myself, we're going to be charged under this law.
Okay. And Tumasi, just your initial reactions as to the coverage and the focus that this has been given, as we've been talking about in the past week.
Okay, so I think some things are getting quite a bit of attention, for example, fake news, but there are two issues we sort of are missing in our discussion on the new law. The first one is on the investigation procedures. So we have part 4 that talks about how police officers will access our information through the service providers. So this part creates 3 avenues of getting our information. So the first type of information is subscriber data. That's basic. Your name, your address, where you live, what service provider, who gives you your internet service. So that's basic. For that, police officers have to go to court and they have to get a court order to get that information from you. Second type is traffic data. So that's the websites you visit. What do you download? What's the size of the files you download from the internet? Who are you sending your emails to? So that traffic data, again, they have to go to court and get an order to get that information from the service provider. Then the third category is content data. So that's the actual content of our communication, our messages, our text messages, our emails. And again, you need a court order for that. So when you look at it, when you give it a first glance, it all seems innocent and okay, as long as they go to court and obtain an order, that's okay. However, there's an expedited procedure that is written in the law, which just basically says if a police officer considers an investigation urgent, then they don't have to go to court. They can bypass the judicial oversight and just go straight to the service provider, write a notice. In fact, they call it a simple notice to the service provider saying that we need this information urgently.
That urgent threshold, isn't it?
No, there's no threshold. It just says that if they consider that something is urgent.
Okay.
Yes. So that's very dangerous because what you've done is that you've given all these wonderful procedures where we have to go to court, but then given the police officers a backdoor where they can just always straight go to the service providers and say, this is urgent. If you don't give me this information, then I'm going to lose key information in this investigation. What's worse is that if the service provider doesn't comply within a given period of time, then they are liable, they're criminally liable. So they have to comply whether they like it or not. Okay. So what we are likely to see is what we would term as collusion, but it really won't be collusion. They'll be obeying what the law says, but they'll be giving our information to police officers without following due procedure. So that's dangerous. That's a dangerous precedent for me, and I don't think we are giving it the attention that it deserves.
And we can talk more about that. Dennis, as a former blogger, and some might argue you are where you are because of your history as a blogger and a trained journalist, do you have any concerns on the aspect of the clauses here on false publications?
Just before I come to that, maybe I would participate in the larger question you asked about the coverage, then I can come to that. I think on the coverage, there has been, like on the piece that we watched, there has been a concentration on anyone you can get who does not agree with the law, and very little concentration on anyone you can get who actually has informed the law. For instance, Adan Duale moved this motion. A message from him. The motion was discussed in Parliament, sound bites from what we'd call the Hansard. the video answered, which because the cameras are there through the Parliamentary Broadcasting Union. So I think a balancing of the story so that the viewer doesn't get, because at the end of the day, an electronic story is believable to the up sounds that you have. So the up sounds in this piece, in my opinion, are not balanced. Okay. Now, getting into the issues of the clauses. First, I'll say, and I'll agree with Mercy, that largely this is a bill that was needed. The CS ICT has already said Kenya is receiving 40,000 cybercrime issues on a daily basis, yes, out of which 11,000 are escalated daily. You remember in 2016 there was a report that said we are losing 18 billion shillings out to cybercrime. You remember in 2015 Kenya was ranked as 69 most vulnerable countries out of 127 countries, and that is a dangerous thing for the investors. And the statistics go on. It's also good to remember that the laws that existed before these ones came long before M-Pesa was here. So basically, these laws bring us up to date on issues that are coming up, like cryptocurrencies and how we can bring them in, bring blockchain technology, yes, and that kind of stuff. But as for the clauses that you have specifically asked on publication,
especially as a blogger yourself,
on the publication of false news, there are two issues. The threshold on the false news is in court. It's not a government issue. It's not a police issue. So investigations are done, and a judge, having seen the evidence, which is clearly spelled out, decides. So it is not government going after media that I've seen most commentaries saying. It is a judge who ultimately decides. And the only bit I disagree a bit with Mercy is on the bit of the urgent, the special bit on police. I mean, if your child is kidnapped, Mark, and we are able to trace the communication between the kidnappers and you're able to investigate. Are you saying we go to get a court order first before we can get these guys who have kidnapped? In 2015, we had the spokesman of the deputy president kidnapped as he got into his house. Mm-hmm. If this law was there, then the intervention would have been faster than it was at that time, because now this gives you, and then it doesn't stop there. The law actually puts a caveat that after doing that, after going through that the special bit of the law, you have to come back to court and justify why you used that particular case. And if you're unable to prove that, then you are liable.
Yes, I'm sure she agrees with the aspect there if someone is in danger, but it's more of the
misreading.
Yes.
No. I think Dennis has just misread what that part of the law requires.
All right.
You don't need to go back and prove why you needed it in a hurry. And in any case, where there have been cases for emergency, okay, you really need this order immediately, there is a procedure to get expedited court orders. So that's what you should provide for in the law. When the first draft of this bill came out, we even had a whole section on search without warrants. And when Parliament was throwing away that whole section on search without warrants, this is the same explanations they said. Yes. There will never be a scenario where you can say, okay, we don't need a court order for us to go into someone's property and search their property. That's the same logic they should have used for
even
this.
in a scenario cited as this as an emergency.
The basic scenario that Dennis is speaking to is well provided for in law. That's why there are ex parte applications in court. So that is what it is. That any time an applicant is not going to be forced to give reasons. It is on the face of the application, what do you want to do? And the court, in believing you, would grant an ex parte order. That has been done all the times. In fact, I would tell people and Kenyans that there isn't any other agency apart from the state that uses ex parte orders more than individuals in the country. Okay. So we haven't gotten to a point where the government is telling Kenyans, we've gone to court on ex parte applications and we've been denied. That's why we are now coming up with this other option. So what I think we need to see, and I liked Den's starting point that we needed to show the discussion. But if we went back to Parliament and saw the discussions that were in Parliament, one, they reduced the import of this law into a small issue of them receiving unsolicited messages from unknown persons. Yes. That watered down the big issue the country was dealing with, cyber attacks. Yes. And cyber attacks are a national security issue. So the reason as to why the cybercrime law is important and why Kenya was being rated law is that there are 4 sets of laws that are required in the whole of this ecosystem. One of those laws is a law that puts clearly allowing electronic transactions, which Kenya has. Then a second law is a law that protects consumers, which Kenya has. A third law is a law that protects privacy and data protection, which Kenya doesn't have. And a fourth law is a law on cybercrime. In thinking about that holistic ecosystem, the discussions in Parliament about a person having access to numbers of MPs without perhaps proper protection would have led us into a discussion why the country needs a data protection law. Instead, we went into criminalizing those aspects without speaking to a bigger issue, which is data protection.
Okay.
And I find that challenging, given that when you look at the objectives of the law, it spells out those things clearly. It does not spell out that we will need a law that criminalizes expression. So all these other sets of provisions that have nothing to do with availability, confidentiality, and integrity of computer systems, and or integrity of data that has gone through computer systems are additions. And that is where the problem begins. Because Kenya is placing itself in the same comparison with other countries that want to trade with us. And they want to see, in the event there is a problem, is this criminalized in Kenya as it's criminalized in the US or as it's criminalized in Canada?
All right.
And that's a challenge. So the reason as to why most people are focusing on these content-related criminal provisions is that they take us away from the main focus, which is supposed to be cybersecurity, into an individualized feeling,
so that's
subjective
the core
feeling
of this new law, you feel? No, that is the weight of it.
That's what it ought to have been. But it has now shifted into extra. I would add that when you think about cyber fraud, cyber terrorism, cyber espionage, identity theft, or intrusion into computers without authorization and the like, those are the core cyber-related offenses. But the moment we begin to get into cyber stalking, cyber bullying, cyber squatting, false news, fake news, and all that, those are extras. And in our country, we need to ask ourselves, we've had publication of false news in our penal code since before independence. How many people have been charged under that law, and what has been the proof? So as we sit today, we have 2 provisions or 3 provisions now in our laws talking about a phenomena we all agree that news is about facts. Truth is a subjective thing. Nobody has truth. We all arrive at discussing facts from our own points of view.
All right.
So who is this who's going to sit and say this is truth?
Of course, a judge.
Yes. Okay. And a judge. All right. Guys, I have to take a break here. The person who's in charge of timing here, that's my director, says I've overrun with a few minutes. So I'll take a break here. Jackso will be back in a bit. Welcome back, and the conversation is continuing even as we are on the break here. But there was a point that you were making in terms of the urgent, the scenario where something is urgent, and then this is a red flag, I believe Mercy was raising in this particular law. And a police officer would come, as long as they feel something is urgent to pursue, they would pursue it. And you said this is actually supported.
Yeah, and that's what I was about to make before the interruption came. On 32, the law says a police officer or an authorized person who misuses the exercise of powers under this part commits an offense and is liable on conviction to a fine not exceeding 5 million shillings or to imprisonment for a term not exceeding 3 years. There is a responsibility and accountability put on a police officer who decides to use the powers wrongly to use that special act. And that's scripted in the law. So it is not something that is fake or out there or that's a red flag. It is a fact in the law. If you misuse it, you are liable.
Yes. However, who brings charges, criminal charges? It's the office of the DPP. Okay? So the office of the DPP is the same office that brings charges against the people the police officers are investigating. Okay. So how do you expect the same office to investigate the police officer who brought who recommended
That
charges to
happens every
it.
day in our courts.
So
Policemen are
it's
charged
not
every
really
day.
a cure. Why write a mistake into the law and then write half a cure into it? That doesn't make sense.
Right.
So instead, we should you should have a law that if you put this law in the hands of a madman, he can do nothing with it. That's what you need to do with this kind of laws. And the other thing is, it's like we forgot why criminal law exists. Why do we pass criminal law? Why do we have laws creating offenses? And this is a basic first-year class in criminology, that you create laws, number one, to keep the bad actors away, to prevent them from committing other crimes, and also to restore the people who've been affected to their original position. If you look at some of the offenses in this act, when you say if you disclose a password without your employer's consent, that's a crime. Are those really criminals? This is conduct that's already addressed in the contract of employment.
Yes.
So it's very easy for your employer to just bring a breach of contract case against you. Again, similarly, if you say that once you leave employment, you should surrender all your passwords. If you don't do so, then you commit a crime. Again, that's a private relationship. The criminal law has no business in that transaction. But Maina was talking about cyber squatting. Cyber squatting brings intellectual property rights issues and it brings personality rights issues. In civil law, there already exists a perfect remedy for this and for civil defamation. Why do we need to drag criminal law into it?
Okay.
Another one that I find very concerning is the issue of reversing money transactions. So I'll use the case of M-Pesa because that's what is most common.
Yes.
So when you send M-Pesa to the wrong number, if the person, the wrong recipient, refuses to send it back, then that's an offense. I mean, this problem starts with the platform itself, M-Pesa itself. Shouldn't Safaricom be the entity to take care of the problem instead of now writing criminal law into private transactions?
Yes.
What would have been better, for example, is to require mobile money platforms to come up with a refund policy and then give them the power to punish even their own subscribers.
Yes.
So if you have dishonest subscribers, you can do what YouTube does. Give them 3 strikes. If still they don't rehabilitate, then flag them. They can't use your platforms.
Yes.
So I have a problem with those last sections. And interestingly enough, Mark, these are sections that were added at committee of the whole stage. So after public participation has already taken place, these are sort of sneaked in at the committee of the whole stage. And this is the first time we're seeing these sections when they're on the floor of the House. No public comment, the MPs themselves don't look like they're actually following the conversation. So somehow we have sections that were subjected to very good public participation. Then we have sections like this that make you question, so why do we have criminal law at the end of the day?
Let's see if there's something else that could actually solve the issue of fake news and false information being published. And this I picked from the CPJ's website, the Committee to Protect Journalists, and they actually had pleaded with the president not to sign into law this cybercrimes bill, but it has already happened. And they say, and this I'm quoting just part of it, Kenyan legislators have passed a wide-ranging bill that will criminalize free speech, with journalists and bloggers likely to be among the first victims if it is signed into law, which it has. And further says, we urge President Kenyatta to refer it back to Parliament so that members can ensure that its provisions are constitutional and do not violate the right to media freedom and free expression. So we get to this, and this is one of your main concerns.
So there's something that I want to bring out. The High Court found that Section 29 of the Kenya Information and Communication Act was constitutional because it lacked definition of key operative words like indecent, obscene, anxiety, among others. And Justice Mumbi Gugi at the time asserted that the words are so wide and vague that their meaning will depend on the subjective interpretation of which others will make, and these are the DPP, the police, and magistrate. This particular law, okay, that was kicked out, right? That was made that particular law was made unconstitutional. This one has words like false, panic, obscene, misleading, and fictitious. So who is going to, basically what Masai was saying, who is going to decide that something is fake? Who is going to decide that what is truth and what is not? The problem with such vagueness is that it creates a path, and it creates a way, for the state and powerful people to to, you know, to get people arrested, you know, for basically saying something that they find uncomfortable.
Yes.
And if you look at, you know, 2015, 2016, 2017, a lot of people were arrested.
Yeah.
Were arrested on very flimsy grounds. None of them have been successfully prosecuted. All those cases are just, you either were taken to court once and that was that. So, yeah. So,
Yeah, so
again,
yes, so to understand, I think what we need to ask ourselves as a country is criminal law the solution to everything? And I think we've become a country that because we hold a hammer, every issue is a nail. We have to hit at it. The starting point is that if the country is struggling with disinformation or with propaganda, which Dennis and his team are purely a formal arm of government propaganda. So, and you want equity, you're talking about fair administrative action. So in the event that Dennis and his team had told us something that has been proven not to be factual, would this law apply to them? Then you notice that that's not how it's going to apply. So the starting point, and for me, I keep saying, because I sat in the task force that was to developing the cyber crime law. And at the point when we left the draft, it didn't have some of these content-related provisions, apart from child pornography, which we had well defined. As you look at it now, pornography is slightly well defined. Child pornography is not defined. In the law, we've mixed indecency and obscenity as if they are interchangeable concepts in law. In reality, that says there is a problem. Because if we were going to fix one of the content issues that we all agree about as a country, is that nobody would like child pornography to exist. That is something that all of us agree. Why haven't we had it well defined and choreographed in the law so that we nab those who will end up either producing or disseminating child pornography?
Right.
The way we've done it is that most people are going to get away with it because what has been defined and what has been criminalized are two different things. And this is where we have a problem with this, because sometimes there is a feeling when you criticize a law, there is this quick bashing that comes your way. You are not patriotic, you don't care about these attacks. We do. And as a person who worked in criminal justice system for 7 years, I understand all this. But I always say, why these gaps? What was it that was so burning that the country could not fix this? And now knowing that where we have such mistakes, we have another 6 months before we can come back to rectify it.
Yes.
This would have taken a week or two for the drafters to look at it, tighten it up, and then have certain crimes that are clear.
Let me give
but
Dennis.
where there are civil offenses, criminal defamation has been outlawed in the country. Our constitution clearly says what we will protect freedom of expression, we will protect media freedom, but where the reputation of others have been impugned, the people will be sanctioned through civil action. Now, we have gone through that during the Security Laws Amendment Act. That provision was there. It was thrown out of court. We had that provision in KICA, Section 29. It was thrown out. We had it in criminal defamation. It was thrown out. Do we bring it back again for it to be thrown out? Isn't this misuse of our time and resources as a country that we are mark timing on the same issue? I would have preferred that more resources are being set aside for this committee to fight cyber fraud that Dennis is talking about.
Yes.
You know, the monies that we lost were in cyber fraud, which is a specific offense. It is not everything. It was banks and people who are getting our money through, or Safaricom was once off air. You know, we couldn't transact money. Nobody has given us an explanation what happened at that time. Are we able to forestall such attacks in future?
To be fair, let me give him a chance to respond to something that you brought up, and also some, you know, alluding to it. You know, like David Mwenda, you say, please ask Itumbi why he supports the bill now, and he has justified the use of propaganda for politics. propaganda could be said to be fictitious and what have you. This to the issue that he brought up.
I also listened to Henry talk about propaganda. I've said on this show before, I have no apologies for propaganda. It's both positive and negative.
What's the difference?
Just a minute. I know I don't interrupt you when you're speaking, so
It's
I don't
okay,
understand
it's
why
okay.
every time I speak, everyone
finish
comes
your
up.
point.
So
Don't make a mountain out of it.
propaganda can be positive, and it is actually can be used to send government information. What is government doing? How is free health coming up? How is housing, affordable housing coming up? How is basically the basic for being applied? You can use propaganda positively, and that is a basic lesson. As she said on law, that's a basic lesson when you're doing communications. But let me quote something, and this is where I agree with the panel, that at one time when there was a case by Buyer Be Aware that went to court, and the section they were saying went off, the judge said, crucially, freedom of expression is constitutionally enshrined and encouraged as a lifeblood of democracy. The freedom to wield fists and firearms enjoys no similar status in our supreme law. Therefore, civil law exists to provide relief and restitution when a person harms or threatens to harm another person's interest. Yeah. What am I saying? There is sufficient opportunity and legal opportunity to be able to, if where private people disagree, to be able to pursue that through the law of defamation and tort, which is actually in our law and has worked for very many people. So it is possible, it is actually in our law. So, but in terms of, and that's now where the balance must come. There is also the bit, whereas civil law requires that you can afford legal fee, there is a cost attached to it. For the person deep in the farms who wants to apply, who wants to go to court, and I've been in a defamation court not once, not twice, and I know how costly it can be. But for that person in the inside of Mashambani who wants to use the same because they have been, something has been said about them and they want to use defamation law, they need some assistance. That assistance can either come through pro bono measures that are promoted by government, or it can actually come through a form of criminal law that allows government to be able to prosecute people who do that. For instance, if somebody comes and says there are 50 people who have died out of a virus attack in Eldoret, please don't go to Eldoret, and that is false information that therefore causes panic to a larger population, then that person is bound to be prosecuted by government. A responsible government must be able to come in and be able to do that. Beck raised the issue of whistleblowers. It is important to note that whistleblowers are the most protected in our law. We have Whistleblowers Act, we have the Bribery Act, we have the Kenya Anti-Corruption and Economics Crimes, we have the Witness Protection Act, even though it protects witnesses, and we have Access to Information Act. All these laws protect whistleblowers at a very large extent. Right. And finally, the International Telecommunication Union gives 5 areas on how to draft a good law on cybercrimes. And I think they have been met largely by this bill. So one, legal measures must be in place. There must be regulations which are going to come up from on the specific areas. There's going to be, there's organization, there's capacity building, especially on cyber forensics, which are a big part of the investigative procedure, and there is mutual legal cooperation, which I'll come to later. All right,
you've given loaded contribution there. Let's unpack it a bit.
Okay, so this is, we can sit here for a whole day and talk about fake news, but this is the bottom line. There are 6 categories of speech that are not protected by the Constitution. Propaganda for war, incitement to violence, advocacy for ethnic hatred, hate speech, advocacy for discrimination, and then speech that affects the rights and reputations of others. So if your speech doesn't fall within those prohibited categories, be it the truth, be it the lies, you have the right to speak it. We have to look at the freedom of expression as to extend to the right to tell a lie. That's what it is. He does well to bring the issue of cost, because he says, okay, civil defamation is costly for some people, so let's give them a solution in criminal law. Except it's more expensive. So this is the reality of it. As media personalities, as bloggers, your work is to contradict the government position. Yes. So imagine how many bloggers then it would be rounded up on this section who, okay, the Ministry of Education says this is the number of children who are not in school, you say this, that's fake news. So the next ministry says this, you contradict, that's fake news. Because remember, it's the same government that's bringing charges through the office of the DPP. Yes. So again, you can't be the judge and the jury. So the cost of, so now you have to resource the office of the DPP, which today announced that it's under-resourced. Okay, you have to, again, resource the police officers who we are saying we keep complaining, oh, you know, security is an issue because we don't have enough police officers. The judiciary, how many times have we heard that the judiciary is overworked? In Eldoret, they had a strike because there were not enough judicial officers. Okay. So think about the administrative staff themselves. So when you look at it, the cost of prosecuting offenses that you could have gone to civil court for becomes higher. Yes. So really, then there's two sections on fake news, and we have to look at them very differently because, first of all, why do we have two sections on fake news? Number two, when we keep throwing around words like unconstitutional, we have to be very careful as lawyers. Not everything will be declared unconstitutional. So we have section 22 that says that, first of all, limits the freedom of expression. And I don't have an argument with that. It goes back and says the freedom of expression does not extend to these 6 categories. And that's okay because Article 33(3) also says the same thing. So the import of that is, fake news, if you're arrested on a charge of fake news, if your speech doesn't fall within those 6 categories, go to the High Court and challenge that charge, challenge that section, so that it only limits fake news that amounts to restricted speech. Right. Then we have the other section that was sneaked in there by the leader of the majority during Committee of the Whole, which talks about fake news that causes public havoc and public panic and violence. We have to remember that when we had the old constitution, public order was ground enough to limit people's rights and limitations. Why isn't public order a ground of limiting people's freedoms in this constitution? It was not a mistake. It's a very calculated decision to remove such vague words from the constitution, from limiting rights such as freedom of expression. So you cannot now return it through an act and say, okay, if it causes public havoc. First of all, what is public havoc? What is this thing we call public havoc? If the government paints a very wonderful picture of the state of affairs, and then you break a story and say, okay, NYS, there's an NYS scandal, and then now there's panic. Does that qualify for you to be charged with
then
public?
We say it's 9 billion, they say it's not 9 billion.
Exactly.
And now it's fake news.
So who's the arbiter of the truth? Then he says it's the courts to decide what the truth is, except that's not the role of the courts. The court is not an investigative court in our system. There are countries where the courts actually have investigators. They go and find out the third version of the story. So there's a plaintiff side, there's the defender side, and then there's the court side. That's not what we do here. What we do here in criminal cases is on a balance of probabilities. First of all, has the prosecution proved a case? Is there a case to answer for the respondent? And then the respondent presents his case. So that's really false, and that's very, very misleading. I heard it with the CS the other day that let the courts decide what the truth is. That's a lie. So the court will be looking to the office of the DPP to say, okay, this was a lie, so let's try them for this offense. Yes. Come on, this is really, what are we doing with this fake news section?
Let's squeeze it in a minute and a half.
We're wasting. I'm sorry. We're wasting so much time and resources with the false publications law, the false publication part of this law, and also section 22. Seriously, can you imagine how much it'll take to to move a bunch of police officers, come arrest you, you're taken to a police station, and then there are lawyers, there's a judge, there's hearings before you get, seriously, this is all extremely unnecessary. We've been here before with Kika 29 and criminal defamation. Seriously, we do not need these certain sections. And then I want to clarify. Okay. The Bloggers Association of Kenya's position on this is that the intention of this law was fantastic, right? Cyber crimes are a menace, and as with other countries, we need them. And then plus also we need a Data Protection Act. But we do not need to criminalize things that are actually not criminal. If she sends me M-Pesa and I get on a plane, right, and she thinks, oh, this person is not, picking my calls as police, so I'll be arrested. Seriously. And then, also, so I write that, like Henry had I had red shoes, and he says, oh, they're blue. Then I'm taken to court for what? Yeah.
All right. On this, sorry, you took the minute and a half that was for Henry, and I'll give him a chance because in the last part we'll have your final opinion, because I'm sure even Mercy has aspects of this that she agrees with, and I haven't heard Dennis say he disagrees with an aspect here, but you'll probably clarify. You've agreed mostly to it. I've actually said. All right, you can clarify further, and especially, and you haven't answered, as a blogger and as a journalist, no concern on the issue of gagging our expression, the freedom of expression. I'd really want you to speak to that honestly from the bottom of your heart, forgetting the job description just for a minute, and we'll be back shortly.
Is that possible?
Could forget it for life. So it's important that you remember it now. You never know. Dennis, I
Fidelity
could just be the one to replace you.
Fidelity to the law.
Welcome to the last part of Press Pass, and I'm setting a target for myself, for us actually. Let's see if we can get within 20 minutes tops the aspects that are actually good in this law, and if there's any recourse to change what we feel needs to be changed, and if the media, the bloggers, are crying wolf in this issue of being gagged by this very law. Let's take some history lessons here. And Dennis, as we were talking, if you were the blogger that you were before you got into government, would you have been able to operate as you had under this law?
I've been guided throughout my blogging life and media life by fact. I have always written what I can stand in court and prove. So even if then there was a provision to arrest me for publishing false information, I would have gone to court and proved. One of the defenses of false information, by the way, is to actually prove that it is not false. So I would have gone to court and defended myself like I've always done and won the case. Yes. So I have no regrets. Even if I was taken under this law, I would have. And Mark, maybe you didn't hear me, but I've also said that this law has been passed yet. But now, I think there needs to be a conversation in court, and I strongly believe, around whether or not we should criminalize what is essentially defamation. And that can only happen in court. So maybe
Article 19, false news
has already been resolved.
Just a minute. I mean, it's been resolved before. It has come back in another law. Go back to court. That is why we exist. I mean, that is why courts exist, so that we're able to solve issues, and that's why we have Article 19 here. We have Baker. Let them move back to court. Let's have a conversation and see whether indeed this law surpasses the thin line that goes into defamation, which is an individual issue between persons.
Do you still feel that you would have stood the test of justice with the charges that you faced?
As I told you, I write what is fact. That is why I can confidently go to court even when I'm arrested and win my case eventually. So I don't have issues. I can prove what I've said. The problem
propaganda would not be seen as a falsehood or fictitious, as
no,
you
Mark,
have
if you
defended
give me an
it.
example where I gave propaganda, I'll be able to react. But now these sweeping statements are very difficult to react to. But if you give one example, I said water was tea, then I'll be able to react.
Yes.
But as long as I've said water is water, even if you take me to the highest court, water will still be water.
I'm angling to the point where Wamathai and the others have an issue to the ambiguity of this fictitious falsehood.
To be honest, Mark,
those are things that we have to prove within a court of law. Now we have a law. The place where that operates and where it goes is not the discussion on that law. It is in court. And by the way, Mercy has made very serious and controversial issues here. That the DPP, because it's funded by government, they're going to be investigating police. And so police, this is government. Let me say this, Mark. When we went through the referendum in 2010, we voted the police as an independent body. We voted the DPP as an independent institution. Then we voted the judiciary as an independent institution. They do not take orders from the executive. They operate on their own independence, so that and the Kenyan people decided on themselves that these independent institutions will be able to prosecute. So once the law is there, the DPP has his role to put his case in court. The judges independently decide, and we have seen them last year, independently decide on the issues before them and make a determination. And because I know we are going to the final round, on mutual offenses, mutual assistance offenses, that part of the law is very, very important. Without mentioning specific instances, there has been a case of international terrorism here. So when the Kenyan authorities detected it, they informed the London authorities and informed South African authorities, because it was a plan that went beyond borders. The Brits have already, the person who was involved is already convicted and sentenced. In South Africa, the case ended last week, that person is convicted. In Kenya, the case has not only has it not begun in court, but the people involved are out on bail. So this law will help a lot, because one of the major issues of that mutual legal assistance to get, because the Brit actually confessed to the crime and gave exactly what they did. In South Africa, it was a prosecution. So that kind of exchange of information is going to be very important. And one of the biggest issues why we couldn't get that was because of the placement of the law. Now, that part of the law will be a very important addition.
And solved, in your opinion, with the international cooperation. Wamathai, you're saying?
Okay, let me just answer your question, because if I respond to Itumbi, we'll just we'll just be here all night. I've already spoken about section 16 and 17, and on whistleblowing, they will hinder whistleblowing in Kenya by bloggers and the media, and then also section 22 and 23 will hinder freedom of expression by online users and bloggers, and also basically freedom of the media. But also I want to also talk about cybersquatting. For instance,
and describe it just for the
cybersquatting. I mean, so basically, I mean, let's say for instance, there's someone out there, who is called Wamathai, for instance, but for some reason they decide to go and register Wamathai.com, right? So that is a name that I'm very well known by, and maybe I even have a trademark to that name.
Okay.
But then maybe they are unaware, or it's their name, and then they go register it. That can be considered as cybersquatting. So this, unfortunately, this criminalizes something that sometimes can be very innocuous. Yeah, not even a mistake. It can be, I mean, people share names.
Yes.
You don't have the monopoly of ideas or things. We can come up with the same name. That's why you find that sometimes businesses, a business can be something media, something investment,
yes.
etc. Also, the clause on revenge porn, in my opinion, is not helpful. It should have been a bit more. It should have been extremely specific, because the problem is not that you have intimate. It's not the issue is not you have intimate pictures of someone. Is that you share them without their consent. Mm-hmm. There's a very good case. I can't remember. Sorry? Yes, a very good case about someone who shared, pictures, or someone's intimate pictures without consent, and so that is what should have been specifically put in, put in the act, saying that sharing of intimate pictures without consent is not allowed.
Well, in Parliament, they pointed out the Deputy Governor's example, where they said this cannot happen again. This is actually the members of Parliament, as you were talking about.
And that's very problematic, because why are we personalizing it? We need to look at the issue like wholesomely. Basically, what Maina was saying. We need to stop. We need to stop putting things into law because it has happened to a powerful person. No, we need to put it because it is something that Kenyans have faced, will face. Not one person, or because how MPs were saying that because they're being harassed, so now we need to put, we need to put clauses in the law. That's not helpful at all. Those laws basically were not made for us.
Yes.
Right? And to be honest, we don't have, as a society, we don't have special laws for special people. All these laws are for all of us. Something else, and this is what something Maina talked about. We need this. We needed a lot of specificity, and a previous version of this bill had it on child pornography. And then, like Masai said, M-Pesa, I mean, that thing about M-Pesa is just nonsensical.
Yeah, but you're going to court, just make clear. or challenging
specifically, yes, specifically because of Section 16 and 17 and Section 22 and 23, and then also, of course, that section on cyber squatting.
So that's KUJ, LSK, and BAKE.
Yes, yes, yes. So KUJ have expressed the intention of going to court. Also, LSK, their public litigation arm, is going to court as well.
Okay.
Yes.
Are we crying wolf with the concern about our expression, freedom of expression?
We're not crying wolf. I think for me, and I say this in good faith and understanding that and appreciate, I think Dennis made some reading to say what is required of a good law. When we measure this law on those standards, it falls short. It would have been better for Kenya to redeem the region by saying when the laws of Ethiopia, Tanzania, Uganda fall short of this standard, Kenya can be the standard you look up to. Kenya cannot be going below those standards. Yet we have government officials like Dennis who have read the principles that ought to inform it, but it's not being reflected in the law. So that's one point. The second point is to remind Dennis we don't have a whistleblower law in the country. There is a bill which has remained a bill for nearly the last 10 years. Different versions have come up and gone. It's important that we have it if for sure we tend to have a reason to want to safeguard whistleblowers so that we give them legal protection without always going just, the rhetoric it differs from what we do in practice. The third thing that I want to say is that a good cybercrime law would understand that there is need for awareness creation and training. There is also need to think through cooperation between the government, economy, and society. Half cybercrime reports or management will not lie in government. It will lie with individuals who control critical information. So if we don't understand that and only think that the best thing is sanctions, then it's wrong. A good law ought to have had incentives and sanctions. And those incentives would have ensured that every person who is using the cyberspace has put into place certain cybersecurity processes that then, accumulative of all our individual efforts, would make the country more secure on the cyberspace. But as it is, we must appreciate that it is a way forward. I'm clear that on provisions that criminalize freedom of expression, Article 19 would continue to engage. If going to court is going to be the next course of action, we will take it because it is a lawful process. And I must warn that those who go to court are not unpatriotic, because we've had statements from government officials or political party enthusiasts who think that those who go to court to challenge a law are unpatriotic. The most patriotic of us want a good law, and we will ensure that it's cleaned up. Right. Lastly, I think for journalists, this is something I'm saying, and I regret, this law was in the making in 4 years. We seem to all have woken up now when it's been passed. I think it is this profession that must be inducted, that things that affect us, we only get to attend to them when we are in a coma. We must learn and wake up so that we engage with these issues when they are still as raw. Perhaps we would have influenced Parliament as much. All right. But the last I must say, yes, the core issues of confidentiality, availability, integrity, and reliability of computer systems or crimes on data that will go through the system, those provisions of the law are sound. It is a whole litany of these others that we've added on that are causing problem to this law. Right. But I also ask Kenyans, in showing its leadership, Kenya must go ahead and sign the African Convention on data protection, which it was part in developing, which has better provisions on cybersecurity and data protection. Perhaps we will have had our own lessons better if Kenya plays both rhetoric and practice on the right side. Okay.
Mercy, I see you pointing. I'm giving you the last word because
Yes,
of your
okay.
lady. But I see him wanting to talk, but I have to give the lady the last word.
No problem.
Make it really quick.
On whistleblowers, there is a bribery act that clearly provides for protection of whistleblowers on its section 21 and has very many clauses on
It's
it.
a section.
It's a bribery act. So whistleblowers are protected. When you go to Kenya Anti-Corruption and Crimes, there is a whole section on whistleblowers. They're protected. When you go to the Witness Act, there is a Witness Protection Act. There is even a creation of a Witness Protection Agency which protects whistleblowers.
There's a whole difference legally
we need
on those two,
Yeah,
Dennis.
but we need to read the law.
I'm happy to help you make the difference
Anyway,
on another program.
Anyway, let me end it this way.
Don't be spreading falsehoods on my show.
Yeah.
Yeah.
I'm happy to help you make a difference between those two.
Yes.
It's not possible. Whistleblowers are
Why would the
protected,
government be
Anyway,
having a
I don't know why
whistleblower
Maina keeps
protection
interrupting
bill
you and I'm
If
talking
there's
if
about
it
already a
has?
law.
Why would government be
Yes.
having
Maina.
a bill
Yes.
if all those laws exist?
Yeah.
Why would it be having?
There's
Give
a
us a
bill,
rationale.
There's a bill to bring you see, even on the public, like for instance, on the health sector, there is a whole health bill which brings together all the laws that are spread in different
Yes.
areas. The same thing with the whistleblowers law. There are laws that are in every sector.
On this, you are in deep seas, my brother.
Anyway,
No,
let me
you
end it.
You would do it,
Let me
yes.
end it this.
Yeah.
This law seeks to protect individuals and their reputation too, because reputation under 33(2) of the Constitution is also a key parameter on information. So it is good to protect individual reputation. And they basically say that at one point, William Shakespeare wrote in one of his plays and said, "A good name for every man and woman is the immediate jewel of their souls." He adds, "Whereas you can steal my purse or my wallet, you have only stolen what was mine and is now yours. But he that fleeches my good name robs me of which does not enrich him and makes him poor indeed." In fact, scripture, and that's my final word,
You must,
by saying,
you must have a good name in the first place.
Scripture ends by saying, a good man is more than good riches.
Yes.
A good name is more than good riches. To be esteemed, and lawyers add before right-thinking members of the society, is better than silver or gold. And yes, a good name is important for you to benefit from that.
You need to have a good name in the first place. Yes, but thank you, brother Itumbi. You always end with scriptures on my show, and I like that. I really appreciate that. Mercy, no pressure. Okay. You don't have to give us a scripture, but you can talk about the recourse as you wind up, and then what you see as some of the aspects that are good. Yeah. And you know, someone here is actually tweeting and asking this on a lighter note: what of those complete fake news and legit as those of April Fool's Day?
Exactly.
Yes. What would happen to someone? People are asking those simple questions. If I spread something on WhatsApp, or if I post something on my Facebook, can I be arrested?
You can and you will be arrested, but you shouldn't be arrested according to the Constitution. And I really wish he hadn't brought up, Dennis hadn't brought up the last point about reputation, because that sort of makes up our entire point. The law of defamation deals with reputation. The law of privacy deals with the right to privacy. Those are very, very different. The Constitution does not protect the reputation of people, it protects the right to privacy. So as long as freedom of expression does not violate the right to privacy, then you should be allowed to speak whatever you need to speak. And then if you defame someone in the process, go to civil court. But that's just a slight correction on his part. You had asked me earlier whether there's anything good about this act at all. And let me break away from the Kenyan tradition where we just say the negatives in everything and point out, yes, despite a few mistakes here and there, there's some good parts about this act. So the first thing is, for the first time, we see a law on harassment. We see a law on cyber harassment. And we might not realize this unless you're a victim of it, but there's a whole world that exists. So far, I've seen it on Facebook, and it's in some occasions, even for us here in Kenya, some situations have turned fatal.
Yes.
So we really did need a law on harassment, especially because the High Court recently gave a judgment where they don't consider leaking of your private information a violation of the right to privacy, because that information is true. So again, with victims of cyber harassment were not protected at all, but now they are. And if you look at the act, it even gives extra protection to children, number one, and number two, victims of ongoing harassment can approach the courts at any hour, get orders. Again, pseudo accounts, the use of pseudo accounts to perpetrate cyber harassment, they've sort of written a solution into the law where you can now approach the service providers, whether it's the platform owners themselves or even just your online service provider, and ask them to give details of the people who are hiding behind the CDO account. So that's a positive.
Okay.
Let's be honest. Then there's child pornography.
Yes.
Really, I don't need to overemphasize why that's an important law.
Yes.
We seem to not either want to protect our children, or we don't realize we are sort of jeopardizing their future in the process. I'll make reference to the Ifikie Wazazi thread, where people didn't realize what you're doing is actually retweeting child pornographic material, but that's what you are doing. So, and then there's the issue of identity theft. I would say it's not as pronounced here because all our information is not tagged on our national identity card, but now it seems that the government is moving in that direction. So primary school children were asked to bring all their details, their parents' details, your father's place of birth, his ID card. So we are going to combine all that information into one card. We're talking about a digital driving license. So what happens when all this information is in one database and then we don't have a data protection law as at now?
Yes.
So having an offense on data identity theft becomes very important, because as we've learned through by watching others, this can be a real problem for people. And then the hacking offenses, I think that's a step in the right direction. In fact, that's a very common. It's very commonplace with cybercrime legislation worldwide. You must have hacking offenses. And what I have to especially applaud those who are drafting this law is including provision for white hat hackers. It's not wrong. We're not saying it's wrong, full stop. We're saying if you're doing it for purposes of research, then that's okay. And I think that's a very good position. Including phishing as one of the offenses, that's positive as well. On the issue of revenge porn, I mean, the section itself is interestingly worded, but at the end of the day, it will protect people who are victims of revenge pornography, and even just sharing photos of whether it's your significant other without consent, they'll be covered. It's just that this will now have the other effect of criminal, even when there's consent, it's still an offense, so that's a problem. My other issue, just before I hand over back to you, is when you look at the coordination committee, you don't see the mention of any county government representation. So it's very national government heavy.
Yes.
And we take this approach that Schedule 4 of the Constitution gives security matters to the national government. So the county has no role to play in that, except we don't exist in a vacuum. So where these attacks happen, so right now we are pushing for county governments to digitize all their systems, and then we don't include them in the representation of the coordination committee. How are we going to know the reports from counties? How are we going to know that our county governments are vulnerable, how vulnerable they are, and what they need to fix? So that's something I think that there's a very huge mishap there, and perhaps it speaks to the old feud between National Assembly and the Senate, that thinking that the county governments just don't need to touch on matter security. That was an oversight.
All right.
Yeah.
And the issue, just real quick, the issue of recourse, some bodies are going to court to challenge this, but to change any aspect of this, what happens?
Okay, so some of these things have very straightforward fixes. So when it comes to the freedom of expression, really what I expect the lawyers representing these organizations to ask the court to do is look at specific sections. Okay. So that what would be dangerous is to just challenge the law as it is and say this is a very bad law, it was meant to arrest bloggers, bogus law, just declare all of it unconstitutional. So that's really not going to happen, and the court has pronounced itself on this on very many occasions. So you have to address specific sections. So go for section 23. Tell them why do you think this is a section that is unconstitutional, and address it vis-a-vis Article 33 and vis-a-vis all the judicial precedent that exists. So that's what I would like to see the lawyers to do. On the issue of public participation, because we've already seen a draft circulating around on challenging this law on the basis of public participation, I mean, it's regrettable that some people are joining the conversation at the tail end. When on Twitter, Beck tried, Kiktanet cried for months, begging people to give their views on the act, and this was the most available. As far as bills go, this is a bill that has been available online throughout the process. So I don't think that's one of the grounds we should be approaching the courts on.
Okay.
But section by section, let's go through the sections and let's point out to the courts what is wrong. And then what the courts are likely to do is, if our petitions have merit, is declare specific sections unconstitutional. And then after 6 months lapse from the commencement of this act, then National Assembly has to look at them. Okay. But in the meantime, the advantage of actually rushing to court at this point is make sure that even the coming into operation of this act is frozen for the time being, that no bloggers and no journalists are arrested in the meantime before the court makes a pronouncement on whether these sections are constitutional or not.
All right. And you make a really good case there, and I'm sure some people will probably approach you to represent them in court.
Welcome.
Thank you, Mercy. And thank you, Dennis. Thank you, James, and thank you, Bwana Henry, for your thoughts. And true, an indictment to the media for making this a big deal now. It's been out there. You can look at this. If my director will just direct us to what I'm looking at, kenyalaw.org. It's there. You don't have to take my word for it or our word for it. Read it for yourself. All 44 pages of this is what you can read about this particular law, what is now law. And yes, you've heard what Mercy has said in terms of recourse. Dennis, this is probably for you as we end on a light note, I think. Gadara, he says, also, this Twitter by PSU Digital, would the folks at PSU have been prosecuted for such if the Cybercrimes Act existed then? This was you saying, the PSU Digital, that one of the gunmen arrested. And I think this is disputed going by the facts. This is on the 21st of September 2013. I guess the point being there, and by many, that this law affects everyone, whether you're in government, whether you're in opposition, wherever you are. You're a layman, and that's why it's an issue of conversation and discussion. Thank you all for your time and your thoughts this evening. Thank you for your attention and making it worth our while. Thank you to the team behind the scenes that helped me in putting all this together. Have yourself a good night.